So the first is accountability. And maybe before I go on with the principles, now as prosecutors, when they talk about violation of the Data Protection and Privacy Act, if you're to review if there's been any violation, you will start with these principles. It will give you that a broad understanding. So one, the law requires that you who is collecting the information, make sure you're accountable. Accountable how? You should have a person who is in charge of compliance within the institution, that the law is being followed, who we call a data protection officer. So if an institution, you find out they misused the information, they mishandled it, one of the things, when you're looking at the file, you need to establish, do they have a data protection officer? If they don't, now that would be one of the red flags. Then the other is lawful. It says that you cannot collect this information without a legal ground. And these legal grounds, they are provided for in the law. None of them is better than the other, but you only consider one which is relevant to the circumstances. So the first is consent. At least everyone knows consent before they collect the information. You should at least give them consent. But consent is not the only ground. Now, with the enforcement arm of government, for police to come and collect my information, they don't need my consent in most instances, most especially about investigating a crime. Now, there they can rely on a ground which is called requirement of law, and whether they are required to collect this information to do something, or the one where within the law it requires them to be able to do that. So if you have a law, now I'll also give one of the Personal Data Protection Office, you are required to register people. Now, when you are collecting that information, we need your consent, but rather we rely on that legal requirement. Then the other is you could be able to, you want to provide someone with a service, so they need to enter into a contract with you. You walk up to a bank, they need to provide you with a loan, or someone is providing you with any other service, so you enter into a contract. Now, contractual basis is another ground. They are under Section 7, which can be relied on to collect your information. The other is what we call the medical purposes. You walk into a hospital, they need to administer treatment to you. So the ground they can rely on is medical purposes for that matter. We also have another one for the security agencies, security purposes. So when you're looking at whether the information was collected lawfully, you need to look at those grounds. So minimality is the other. Even if you have the legal ground, make sure that you only collect information that is minimal and relevant to that particular ground. So if the person has given you consent, it should be information only for that in regard to the consent. If you're required to, by law, to collect it, only collect information that is required by law. Then the other is retention. Now, retention is also informed by the purpose. So if the law requires you to keep that information, you have laws that say keep information for 25 years in the health sector, 10 years in the financial and insurance sector, so only retain that information for that period. Where you do not have a lawful basis, then at least it should speak to the ground or the purpose for which you've collected the information. And ideally, this is recorded in what is called the Records and Retention Policy. So the other is about quality. Always make sure that the information you collect is complete and not misleading, because of the effects it can have on the person from whom you've collected the information. So using the platforms or the channels, make sure that, as you've seen with mobile money, before you send the money, they ask you to confirm the names. So manually, you can also ask the person to read the form and confirm if that's the right information. Then transparency, we'll look at it later. The law requires that you're transparent to the individuals from whom you're collecting the information. Tell them who you are, why you're collecting it, how long you'll keep it, and how you secure it, which ideally is part of privacy notice, as we'll see. But I know with investigations and prosecutions, sometimes this principle may not be applicable, whereby you may not necessarily give the person all the details as to why you're collecting the information. So at least in that regard, the locators for people within the enforcement arm of government. Then security. Security cuts across. This information should be kept secure. Shouldn't be authorized by people who are not authorized to access it. And also should be, a copy of it should be backed up in case it's lost. You can always have another copy. So to drill down into these aspects of the principles, we're going to look at them in a little bit of more detail. So leadership, it's about being accountable. So every institution is required, we advise them to have a data protection officer. Now, this is the person within the institution that will tell you, okay, this is what the law requires of you to do. In case there is a breach, these are the people you should talk to. Number one, with the regulator. If the regulator advises you to reach out to the individuals whose information was collected, this is how you go about it. Now, this particular person we advise should come from these backgrounds, either a lawyer, because it has aspects on interpretation with the law, or someone from an audit background, or assurance, and the other many things to do, with checking controls. It's not advisable to have a data protection officer being the one doing the collection, then putting controls in place, because there you will be the person who is doing the work, and then at the same time the police. So you cannot police yourself. So it's not advisable to have people from backgrounds. Maybe, instance, we don't advise IT officers, we don't advise people who are in administration to be data protection officers. Now, the other requirement is the law requires every person to register. So why is it important? Is that one, it's a mechanism. Number one, it's a requirement of the law. Second, it's a mechanism that we use to know who are collecting and how to train them. Now, we'll be coming to you very soon to prosecute those people who have not registered. We gave a deadline of 31st of December 2021, where every person should have registered. As of today, we've registered about 368, but there are a lot more people who have not registered. We started a campaign sensitizing people how to register, how to go about it, and written to some of them. But some people are still adamant. They've not, heeded to this call. Now, the biggest challenge with this and why we are enforcing it is that sometimes when you talk to people about data protection, you ask them, okay, which information do you collect? They say, no, me, I don't collect information. Maybe I just collect from my clients. But the law says you also collect from your employees. So these people that we've talked to, written to, and they haven't heeded to the call, we'll gather the evidence and come back to DPP, and we start the prosecution, because the law allows us to either or imprison these people and also levy a financial penalty on the institutions. But of course, this is done through courts of law, and after the investigation is done, the files are forwarded to you and you review. But the process is about you complete the forms, we review them, pay registration fees of 100,000, and then when the application, you consider it complete, we issue you the certificate. As you can see, the fees are very affordable, so a person who is not registering clearly cannot say that they can't afford. And this is an annual fee. So I talked about transparency. So this transparency, the information that is required to be given to a person before the collection of their information, is in a document called a privacy notice. Now this, I'm sure most of you who use online services, you've seen it. It can be through a website. It could actually be through, let's say, a CCTV camera, they have a signpost, or even should be read out to you. So like I told you, the law requires that always inform a person before you collect this information. And within this privacy notice, also inform them, the people with whom you may share it with. We did an investigation a year ago where someone made a complaint. One of the ride-hailing companies in town collected their information, shared it with another company, and they hadn't put them in their notice. Now there, you cannot say the person consented because they are not informed. We gave them a warning because it was the first scenario, but in other instances where this is not adhered to, it's where we'll actually go ahead and prosecute them. The other is the policy. Now, the law requires that the people who are within the organization, you should have a policy to guide them on how to go about with the collection and using this information. So when we do audits as regulators, we see whether you have such a policy to guide the employees. Now, as part of our evidence gathering of non-compliance, we check for one of these. So maybe if a file comes to you and it's a matter of prosecuting someone who misused personal data, ask yourself, were people informed? Did they have a policy that guides them? If they don't, that's one of the red flags of which you can rely on to see how to progress with the prosecution. So awareness and training is very key. Now, maybe before I proceed, I'm going to ask you to help us interpret this image. I'm going to start with Hajat at the back. I don't know whether I could be calling someone Hajat and she's just covering her head. I don't know if she's... Where is the microphone? Sorry, you can speak up. Help us interpret. Are you able to see it? Okay, as she's trying, we can choose another person, the gentleman here. Help us interpret that. You can't see it. No, you don't have to read the words. It's about the picture more. There is no right or wrong answer. Please attempt. Eavesdropping. That's a good one. Another try or attempt. Anyone? You always speak up in court, please. Any other attempt? Yes, please. Okay. Waiting, yes? That's a good one. Yes, the lady at the back. Lack of privacy. That's a good one. Yes?
My opinion is that when it comes to data awareness, it doesn't need to be physical.
Okay. That's a good one. You've all given correct responses. Awareness, and then the gentleman, seems to be only standing at the back. Now, when we go in an institution where there's been a breach to do an investigation, we start by asking those people if they know that person. But in that institution, it is very clear that gentleman doesn't know what she does. And the gentleman is also not doing the awareness that is needed. Now, one of the roles of a data protection officer is that you should create awareness. And people should know you. And if people don't know what you do, that means you're not creating awareness. So we start by asking whether data protection is included as part of the induction. Refresher trainings are given. Now, if people do not know what you do or how you go about your work, that is another red flag whereby we can say, this person is not creating the awareness that is needed, and we cannot term this organization as a compliant one. So when you're reviewing to see whether an organization has violated the law, those are some of the things that you should always look out for and ask. But thank you for the attempt. Now, the law requires that every organization be aware, no, not make very witnesses, you can use the existing mechanism. No need to get for both data, decision box, or you can have research but the difference is the lower data, they can be component so maximum data. So if you walk in, you see components and realize that some of the components are that's a defense, then that will be so you look at what record management. Now this record management is very important beyond personal data. So the that type of collection and use of information. So it starts with creating the record, whether when people you have their resume or whether onboarding customers, then application to sign for the supplier, sign contracts, then find out the creditors are, sign. So you have created those records. When I'm going to do different types of percentage, that personal data is not just about that, about that whole thing. So this is supplier. So it also looks at distribution, so the information, there are various share. Then the active storage information, maybe cabinet, the laptop, then the random. The information that you cannot use, how do you report it? The information that you cannot use, this is what we call archiving. Now, the law gives limited which information should be archived. So, this whole cycle, what is called coming through the investigations, we're going to check if you have so the other is data sharing. Now, when we have just started work as the Personal Data Protection Office, most of the requests for legal advice, interpretation came from data sharing. Now, there's a lot of data sharing where, let's say, the telecom company wants to, whether I give the example of government disbursement funds. Remember the problem with funds. So here, they needed to confirm that the people are registered, they have national ID numbers, they have. So they needed to share this information near the telecom companies with their names. Now there's a lot of data sharing. But what they don't require is that you should have contact with these people to ensure that they protect this information at the same way. So you already have going to work. You have these contracts, and they can sign. Do they give you ability for you coming and conduct audits to see to protect the information and the same way for that? So the other is the breach. Now this law requires that where there is a breach, immediately report. So if you have processes that enable you know notifying and seeing that there is a breach, then you can out immediately, and then as the regulation advice how to handle it. So information security we talk about it, it's basically about making sure you know where the information is. And then on here I had of the trial, the CIA. Information security. Because you know now the using information system very critical. And then on top of the CIA information stability, can anyone attempt what the CIA is? And no one. We all have a smartphone, right? They are password. Maybe let me the ready here. So I think that's some basic question. Not to offend you. I give a smartphone. Yes. Does it have a password? So who came up with that? Why did you come up with that password? We went there. Now the password The CIA info, we're going to go one by one. It's called confidentiality. You have password because you want to stop other people from reaching our confidential information. Now, you could have systems that you access to have passwords. So the first under information security is that you have what are called controls to ensure that other people do not access the information that you are not ready to access. The first one is the password. Then the other is where you have thumbprints. No, you don't need to see inside those, where you need to place your thumbprint and access. In case you're not part of the people who are required to have these thumbprints embedded in you, you can't access the premises. So that's the first. Then the I, the integrity. So using this example, has anyone here worked as for interface with the financial people who pay our salaries? Okay, has anyone paid salary bigger than what they expect? Salary, any amount of money. Have you paid someone more money than expected? Now, that's the concept, that you shouldn't change information unless you authorize. So if you send a person more money, then that means you've made a mistake. So these telecom companies and the people in finance who pay the salaries, they have controls to ensure that only what is required or approved is what reaches you. Otherwise, that concept of integrity under the CIA will not be observed. Then, has anyone lost a laptop or a file? Sorry? Okay, the phone is the most common one. You've lost it. How do you react when you've lost a phone? What are your biggest concerns? The information and contacts. But usually, how many people back up their contacts or address book? Sorry? Once in a while. So the last in the CIA is what we call availability. Now, availability says that in case information happens to it, it's lost in the equipment, make sure you back it and it's available so that you don't entirely lose it. So that is what information security is about, the CIA. Keeping information confidential from people who are not restricting it from being accessed by people who are not authorized to access it. Integrity, making sure that you actually do not change the information in ways you don't expect it to be changed, and making sure that it's backed up. Now, when you talk about information security, sometimes we are lawyers, most of us, right? When you meet IT or information security people and they talk about information security, it sounds like a very abstract concept, but I think after today, we'll know what it's about, right? So when you walk into an institution to do investigations and about information security, we always look out for that. And the triad that we talked about is in a policy called an information security policy. It is different from a data protection policy. So now we get to the part where we talk about the offenses. This law creates offenses. It has criminal aspects to it. So now the offenses, the number of them will go one by one. So the first is that if you unlawfully obtain, disclose, or procure the disclosure of personal data to another person, then the law will catch up with you. Now, unlawfully, remember the principle of lawfully that we talked about, that only collect information lawfully. Who can remind us the legal grounds you can base on to collect information? Maybe we can start with the lady in green. What's the first lawful ground, the basis for you to collect information? Medical good. Then, security. This is a very good one. The third, another ground, legal ground you can rely on to collect information. Okay, investigation is under requirement of the law. It's a good one. What's the other lawful ground? Consent. Remember, we talked about consent. So here when you talk about unlawfully, you go back to those legal grounds and check, okay, did they rely on consent? Did they rely on medical purposes for you to be able to tell that this information was obtained unlawfully? So the financial penalty is 240 currency points. How much is that in Ugandan shillings? I know we are lawyers, but I believe in math we are better. Eh? How much is 240 currency points? 4.8? Because each currency point is 20,000. Then imprisonment and or imprisonment of 10 years or both. So the second offense is that where a person unlawfully destroys, deletes or conceals personal data. It's also the same. Now here, remember, when you talk about unlawfully, we go back to the other grounds, the lawful grounds, either consent required by law, medical purposes to provide a contract. And then when you talk about now retention, remember under retention, we talked about having a retention policy, that cycle of how you collect information. So the other is the failure to register. We've already talked about this. The law requires every person to register. So if you haven't registered, you can be imprisoned up to 3 months and a currency of 6 points. Then the law also makes it an offense for you to sell or offer to sell personal data. Now, we've had instances where, people create databases or lists of people, and then they sell this information, be it for marketing purposes, or maybe you've been added to a wedding WhatsApp group, or collection for a particular purpose. Then people download that information and now use it to send you to market their products. That's an offense. Now, the other is where you knowingly give false information, where you're registering. It's also an offense, 6 currency points and imprisonment of 3 months or both. Then the other, they include where you're processing or you're transferring information outside Uganda. Now, the law requires that for you to transfer this information outside Uganda, you should have done either of these. One, you obtained consent, but where you can't obtain consent is that you've done an assessment that that country where you're transferring the information to has similar levels of protection as accorded by the Ugandan law, and that should be documented. So where we find that you violated this principle, you can be fined 2 currency points for every day that you are in default, where we established that you transferred the information, and also imprisoned. Then where you collect information without consent, where it needed consent, you can still be given a financial penalty for every day that you are in default, and also be imprisoned for 6 months. So where we are conducting investigations and we come in to examine documents and you don't honor our request to provide the documents, still there is a financial penalty and imprisonment. The law gives us ability to give notices. We can let you know, we put you on notice that you're violating the law, you've done ABCD, or you're required to address it in such a way. Now, these notices which are issued by the office and you do not comply to them, still you can be given a financial penalty and also be imprisoned. So now the bigger penalty, which is you can be fined up to 2% of your annual gross turnover. That is for the private institutions. Now, this is for, the very grave ones. But even beyond this, the financial penalty, you can actually also be asked by courts of law to compensate the person where, they've experienced distress, emotion, and all that. So as you can see, the non-compliance actually carries a very heavy penalty. I've already talked about the imprisonment in the various instances. So now let's look at how courts of law have at least determined the right of privacy. There hasn't been a lot since the law was passed in 2019 and the regulations just last year, but there is a case. It was filed in around 2009-8, but at the time it was determined, the act had already been passed. But remember, the determination on which it was relied on, it comes from Article 27 of the Constitution, the right to privacy that we talked about. So what happened in Lubega versus MTN Uganda is that Red Pepper had run a story about this gentleman, Lubega, being involved in infidelity-related activities. So he sued them for defamation. Now, Red Pepper presented as part of their evidence call records, showing that actually he was involved in infidelity. Now, later it turned out that these call records, Red Pepper had obtained them unlawfully. They didn't have a legal ground. They didn't get his consent, they're not required by law. And the court order which they had relied on was a fake court order. So for them, when they got this fake court order, they presented it to MTN Uganda, and MTN printed out the call records, certified them, and handed them over to Red Pepper. Now, court faulted them. Number one, they did not verify this court order. It was a fake one. It was never issued. And secondly, they did it illegally because they didn't have any lawful ground. So they were fined and they were given, the gentleman was given damages of up to 10 million Ugandan shillings, and then interest rate for every year. So it was about 10 years due to the breach of the right to his privacy and also causing him embarrassment. So as you can see, court is very serious about penalizing all those who do not observe this right to privacy. But now with us as the regulator working with you, we are looking at ways how we can ensure that this right is preserved. Of course, our intention is not always to prosecute people, imprison them and have them fined. We have other mechanisms to ensure that it's done and there is at least an amicable settlement. But where it fails, it's where we are going to come back to you. But it's critical, for you to appreciate what this privacy is about. So with that, I end my presentation. We can have questions from the presentation and maybe any other matter related to it. Thank you. Okay, any questions? Yes, please. The offenses. We'll share the presentation after. So if what? Yes, they are. Oh, no, there are very many examples. Not to make it too lengthy, we just include a few, but a photograph is personal data because you can be identified from it. Excuse me, a person can be able to tell, this is Marion, this is Becca, because personal data is information from which you can be identified. Yes, Marion.
We always see this share.
Now, that's a good question. It has very many angles to it. Some of it, it's illegal, unlawful, then the other are not. I'll start with the ones where it's not. So I've come here, I'm presenting to you, so I've made myself available in a public place. I'm aware there are people taking pictures like she is, and I could also attend a wedding, where I know, of course, at the wedding, they will be taking pictures. or I could be demonstrating in town, you know, and I expect the media to come in. So if I put myself in such a position and a person takes my picture, I cannot turn around and start saying, you never got my consent, or you never did this. Because in such a scenario, you are putting yourself in a position where you expect your pictures to be taken. But this is different. I could be in town, I'm driving, I'm in my car, and I'm going about. If a person takes my picture, whatever I'm doing in my car, and they go ahead to publish it, now there is breach of my privacy, because I do not expect a person to be taking my picture and sharing it for such purposes. Now, the other example where the recording, so I meet up with a person, or maybe you, let's say, go out on a date, or you are in a meeting and you do not expect any recording. In other words, it's confidential, and someone secretly records the meeting, records the interaction, and they go ahead to actually share it without your consent or without any legal ground of doing so. Then there you'd have breached privacy. So I think you see the different scenarios. I hope I've answered your question, Marion. Okay, thank you. Yes, please. Collected and used using electronic platforms. But the Data Protection and Privacy Act goes beyond that. You know, a person could have unlawfully obtained your information. You get it? They either possibly find it in a room, which is locked up, come to your desk, they take a picture. So for it, it goes beyond just information collected using electronic platforms. I hope that is clear. You know, Computer Misuse Act, it was made to penalize anyone who misuses computer systems, laptops, systems, whereby generally any information beyond personal information. It could be company information. I'll give you a very specific example from the Computer Misuse Act. The Computer Misuse Act says, if you go ahead and share information where you're not authorized to share it, then it will penalize you. Now, this information, which has become a very common, could find a directive has been given, or an office communication. So it's not, doesn't have personal data per se, but it's communicating something which is, maybe they say they're going to restructure the organization. So this is an internal communication. So someone will take a picture of that memo, then they start sharing it, let's say, on WhatsApp. Now, the Computer Misuse Act penalizes such a person, saying that you should have authorization to share it. On the other hand, with personal data, if a person obtains information, secretly records me, we are interacting, and I do not expect you to, or I've even outrightly told you, this is a confidential conversation, then you go ahead and start sharing it there, it would be incriminating me as an individual, as opposed to Computer Misuse Act, which talks about general sharing of information using an electronic system. That's just one of the scenarios. They both have unlawful sharing, but the other one is of personal information, the other one is of general information, but specifically using an electronic system. So the two will be, have common elements around the platform you've used and how it is done, but the information which is shared is where they are not similar. I hope I haven't confused you. They are very similar, but you know, the Data Protection and Privacy Act, in regard to illegal sharing and use of information, it has more stringent penalties. So if you can still prosecute the person under the Computer Misuse Act, but if you really find that it is gross, then you can go under the data protection because it is more specific. And you know, the computer misuse is about penalizing. It's a criminal law legislation. But the Data Protection and Privacy Act gives a lot more, gives you your rights, accessing your information, which the other one, it's more of you've been offended, information is taken, an investigation is done. It doesn't go into that much detail. Yes, Marion.
Information system and computers. So, yes, we shall understand slowly. Yes, it cannot come fall in place in just one day. Yeah. So when the violation is about personal information, my name, my picture, my national identity card, my biography, then that you apply the personal data and privacy law. But when it's about you sneaking into my computer and stealing my password and then acting as if you are me, then that is the Computer Misuse Act.
In very many words, but thank you for summarizing. Yes, you can go ahead.
Accountability of this kind, especially when it comes to discretion. When you, for instance, when you read section 1, talks of the application, that applies to person, institution, and public body. Collecting, processing, holding, producing personal data, outside the data, collects, processes, holds, produces personal data, relating data something. Now, in relation to that, you are talking about aspects that requires particularly identity and persons to register. And the two parts do the process of registration. But my question is, how wide is this act? Because, for instance, I may get personal, I may collect information regarding someone. I may have information regarding someone. Will it require me as an individual to come also the register, with the meter? Specifically, when it comes to the process of registration, we are requiring things such as the telecom company to put the name of the personal information. We are requiring maybe to the banking agencies. What is the scope that is applied? Require one to register. So to me, it seems to be too wide to me. I don't know whether you get my.
I do. And yes, the scope is wide, but within the regulations, we are required to come up with a list of persons who are exempted from registration. It's still in progress, but at least what I can tell you is persons, individuals who are collecting personal data for their personal use. If you're collecting, you're part of a household, you're only collecting information maybe about your family organizing a wedding, a burial, an event, or maybe it's sort of something which will really be used within the confines of your home. You're not required to register. Then the other most common one, of course, we have phones. There are phone books in there. So you have this information, you collect people's names, email addresses, and it is really for your personal communication. In that regard, you're not required to register. But even if you're an individual and you're collecting this information to provide a service, to set up a business, and those related aspects, you're required to register. And this registration goes both ways for government and the public sector. Yes, there was another hand. Mhm. Good question. Now, your office is both, and this is how, is both a controller and a processor. As a controller, it definitely has employees. When you're being hired, they collect your information, your academic background. Isn't that so? Then you also set targets, which you're reviewed against, whether you've passed this, you've achieved these targets, you've done that. All those records are kept. In case any disciplinary action is taken, it's also kept on record. Now, that mere determining which information to collect and keeping it makes the DPP data controllers. Then in most institutions, I don't know whether it's the same with yours, they have systems where they record suppliers. If you're a supplier, they get your account number. In government, it's common using the IFMI system. The directors, whether they have powers of attorney to sign the documents. So in that regard, you're also a controller and collector because you're collecting as DPP for those purposes. Now, in respect to investigations, you're processors, but you can help me understand it better. It's police that goes out, to collect this information as part of the investigations. They put the information in a file and it's forwarded to the prosecutors, either to prefer charges or maybe to close the file. Now, that way you do not reach the people from whom the information is collected, but you're only acting on information which has been collected by police, which makes you a processor in that matter. Yes, it is. Yes, please. Yes, please. Now, you're both at the collection stage, procurement stage, to be specific. People respond to your bids. They give you details of who the directors are, the powers of attorney who can sign on their behalf. And then in case you're looking at a consultancy contract, there are qualifications. So that way you're determining which information you want in a bid and you're collecting it. It makes you a controller. Now, back to your example of finance. Now, finance, remember, this bit of controller processor only applies to the institution, not to the employees, because finance is acting on behalf of DPP. So even if in actual sense they are working on information already collected, they cannot be termed as whether controllers or processors as long as you're an employee, because you're acting on behalf of the institution. So that's how it looked at. Now, it would be Ministry of Finance, which would be the processor, because when we are in government, you're to be paid salaries, lists are compiled, sent to Ministry of Finance, Public Service. Now, them, they are processors because they are working on information collected by DPP. The different grades, thresholds, who to pay how much, for them, they just work on disbursing of the funds. Yes, is there any other question? Yes, please.
Make money out of, they come to make money out of the pictures they take. And sometimes before they present the information, they ask for some payment. Give me this money or I publish this. When I look at this act, I find that there is no provision that covers aspects where people collect personal data and use it for making money.
It is there. There is a provision which makes it an offense to sell personal data. Let me look for the section.
Section 37.
Yes, it makes it an offense to collect information and sell it. But within the law, it says you can sell it if you've entered into an agreement with the person from whom you collected that information for their benefit.
I'm not talking about selling, but
Making
people asking
commercial.
for ransom, pay me or I publish.
Someone saying, pay me or I publish.
Yes.
In other words, threatening or...
Yes.
Now, you know, the Data Protection and Privacy Act is interpreted with other laws. So that way, that sounds more of a tort, right? A civil wrong. You can correct me. So if a person has collected your information and they are threatening to use it in a way that will harm you, then definitely you can find remedy within tort law. Yes, Marion.
Principles of data protection. When you're collecting, you are supposed to be transparent with the data subject. You're supposed to tell the data subject why you're collecting their data, what you'll use them for, what kind of information you require. And then when it comes to use, you are supposed to use that data for the purpose for which you collected. You're not supposed to deviate from its use. So now if your pictures were taken for a particular purpose, and now the person is beginning to say, now we change strategy, now you must give me money so that I don't publish. It means that he's now beginning to publish when the intention was never to publish. So that, I think, it's still covered within the law.
Thank you, Marion. That is correct. Any other question? Yes, please.
Yes, I am seeing here that this law came into force on the 3rd of May 2019. Now we are here discussing issues to do with personal data protection and privacy related aspects. Now, while we are discussing, so many things came into place. One, I was imagining, as of now, do we have a register of data protection register? Because there are so many things that we give our personal information, even beside the companies, even when you go for social media platforms. For instance, you want to join Facebook, there is a process that you'll go through. You're going to join WhatsApp, there is a process you go through. Your accounts, or maybe Gmail, etc., all those you provide your personal information, or even some applications that, for instance, vacancy related. So now my question is, basing on this act, as well as the authority, NITA, do we have a personal data register so that before I indulge into giving my personal information to anybody, let it be on social media, let it be a company, let it be anything, I verify to see whether these people are among those that are registered, that I would feel comfortable to give in my personal information. Because a lot of things now are going through my head and I'm just imagining right now. Maybe you can clarify. Thank you.
Yes, we have that register. It's on our website. It's publicly available. Right now, it has about 368 institutions registered. So you're at liberty, to search, put in a name, and confirm if the company is registered. If they are not, then it's one of the methods, rather one of the areas you can complain about. We've had instances where an institution was collecting people's information. So they asked them, okay, show us your commitment that you are willing to comply with the law. Show us your registration certificate. They did. Now, being registered doesn't mean that you're fully compliant, but at least it goes to show you've taken the first step in taking compliance seriously, because the registration process will give you a proper understanding what information you collect, why, with whom you may keep it, and enable you to do the rest. So you can go to our website, www.pdpo.go.ug. Then on the landing page, you'll see search register, and you type in any name of the institution and see if they're registered or not. Okay, I guess that's it. Okay, thank you. Is there any other question? Okay, let's respond to the ones which are online.
There are two questions online. The first one is from Awani Machulet Angutuko, and it is that there is a common practice by companies or individuals sending unsolicited adverts. E.g., she mentions a company is fond of sending regular adverts to civil servants to obtain loans. It is not clear where they obtain this information from. Can they be liable under this law?
Yes, and we have a complaints mechanism, so you can visit our website. You'll see file a complaint, or you can even use your phone. You press *260#, and you file the complaint, and we get it. But what we encourage is before, it can be able to give you the letter, but before you take up the complaint with us, complain to the organization, give them 30 days. If they don't respond, then you can have that evidence that we can use to actually prosecute them. But that's one of the areas under the law that we can task them and penalize and say, okay, you have my information. Where did you obtain it from? How are you keeping it secure? I no longer want to receive such messages, amongst others.
Thank you. The next question is from Jen Musimenta. There are people who call themselves private phone trackers. They get people's call data from, say, MTN without court orders. Who is held liable, MTN or the phone tracker?
Both. But you can't determine since I don't have all the facts. But what we advise is that you complain to MTN and even those people directly. If they don't respond to you satisfactorily, now it's where you get to us. We investigate and find out how they got that information. If we find them liable, that's where we'll come in and prosecute and come to you, DPP.
Yes, those are the questions we so far have from the online platform. Thank you.
Okay, I guess that's it. Thank you for making time. I know it's been a lot of information, but we'll share the presentation. Then we'll be having more sessions where you can ask more questions. But even then, we are closely working with Marion. You can always reach out to her. She's certified in this area, but then also giving you guidance, but also seeing how where we need further guidance from the regulator, we can work around and see we get this information. Our intention is, as DPP, you're one of our key partners, because, you know, we don't want people to say, I don't know that you heard of that saying, Uganda has very many good laws that never work. We are very intentional to make sure that this law works. And one of the ways through which a law can work is one, creating awareness of which we are doing. Then secondly, warning and putting those on caution that are not implementing the law. But also, if in case all fails, enforcing it by imprisoning, ensuring that court levies the financial penalties. So you are really our critical partners in making sure that this law works. We're the first country in East Africa to pass it. We've had many other activities that we've done first in the region. And another that we want to do is enforcing it. So we'll be creating channels whereby we can see that this law is actually enforced. And most importantly, people's privacy is respected. Thank you. So we don't have administrative announcements, but we have breakfast. So if you can, someone is going to guide you where you're going to get breakfast from. I hope everyone got a pack of the Act and the FAQs. The FAQs have, you know, the frequently asked questions. The regulations are not there, but you can find them on our website. Yes, please.
Would it be criminal to investigate your husband? Collect data about your husband? Can your husband sue you?
I think the position of the law, you can remind me, is that
Are there
you can...
exceptions to this law?
No, the exceptions, not really. But you can sue your husband, but you know you can't be a witness, right? Is that the position of the law?
And what about looking at his phone and him looking at your phone?
Yeah, of course you can if you have the evidence. Okay, I guess that's it. Yes?
I do not know how many we had online, but I was just inquiring if we could have copies of the law for people who attended online.
Okay, what we're going to do,
Yes.
we are going to send you soft copies, both the act and the regulations. Even those that have attended here will, for the regulations, we'll give you the soft copies. The hard copies we don't have for now. Okay, I don't know whether any of you would like to say something before we close, or Marion, to say something before we close.
Thank you very much, Becca and Nita, you, especially the Personal Data Protection Office, for organizing and facilitating this training. It's the first of its kind. And thank you very much. The ODPP staff who managed to make it here on short notice. And I'm also glad you engaged very well. You expressed a lot of interest, but I must say that the Personal Data Protection Law has been enforced since 2019, and it's not very nice to hear that we've not implemented it and that we are not yet aware of the law and its provisions. But I am also glad that we've started, and I hope that we're going to keep the discussion going and that we shall, from today onwards, begin making attempts to apply this law. We should not be shy. We should make attempts and apply this law. It's only by its implementation that people will get to know. The law will get more publicity when we begin implementing. When we have prosecutions under the law, then of course it will also have its own deterrence effect. So I thank you very much for coming and for being actively involved. And I encourage you to continue with this discussion on our forum and in your small groups so that we can build this knowledge further. Thank you very much.
Maybe before we head out for breakfast, we can have a group photo for our archive. Thank you.